The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Welcome to Deep Dive with the Institute for Justice. I'm Melanie Hildreth. When Abdallah Batayneh tried to open a resort shuttle service in Steamboat Springs, Colorado, a state regulatory agency affirmed that he is operationally, managerially, and financially fit to do so. Then they denied his application anyway. I'm here with IJ attorneys Justin Pearson and Will Aronin to talk about what happened to Abdallah, the unjust laws that made it possible, and what needs to change to ensure that other Colorado entrepreneurs can innovate and meet the needs of their communities. Will, let's start by talking about Abdallah. Where does his story begin?
There's no other way to say it. Abdallah is just a great guy. He is the American dream. He came to this country as an immigrant from Jordan. He is one of the hardest working people I know. He has an infant daughter and a wife, and he wanted to start a shuttle company. He loves the mountains, loves the nature, and wanted to help people visit the area. So he did what everyone thinks you're supposed to do. He tried to open the company. He got a van, or he arranged to get a van. He sought the permission of the Public Utilities Commission, and surprise, surprise, the other companies, the shuttles that already existed, they objected, interfered in his application, and now the PUC won't let him do it.
So let's unpack that a little bit. So he did the business planning, he got the financing, he got the van, the insurance. As I said at the beginning, the government agency says he had everything lined up that he needed to, but he was denied. You said that the agency wouldn't give him the permit that he needed to actually open the business, and that was because of his competitors. How is that possible? How does the fact that the competitors object even come into play when you're considering whether or not to let a business get started in Colorado?
So unlike what everyone thinks a business is, you open a store, you open a shuttle, and your customers come and choose to go with you. Instead, in Colorado, you have to apply to the Public Utilities Commission, and they decide if something called public convenience and necessity requires your product or requires your shuttle. And what that means is, first, quite reasonably, they determine whether or not you're fit, whether you can run it, whether it's safe, whether you have the car, whether you're operationally fit. The Public Utilities Commission found that Abdallah is entirely qualified to do this. That should have been the end of the analysis, but as we can guess, it was not. So instead, what they did was they let the competitors, the existing shuttle companies, come in and intervene and say, you know what, Abdallah's shuttle is not needed. We're doing a perfectly good job. Competition's not good for us. Keep him out, commission. And the scary part, the ridiculous part, is that the commission listened to him and said that nothing else is needed, that public convenience and necessity does not require competition, instead just protected the cartel.
And that's after he had already taken all of these steps, presumably put quite a bit of time, if not money, into it as well. And does that just shut him down? Is there an appeal process or some other way that he could kind of try to get at being able to go into business?
Well, there's us. We came in and we are suing to let him into business. But no, this was the end of the line for him. The Public Utilities Commission said, no, we don't need another shuttle. He could have tried to go into court and appealed for years, but in the end of the day, the commission would have kept him out, and we're here to try to change the law.
Right. I mean, the commission was actually following the statute. Right? The statute required them to deny him because he might actually give customers more choice, and someone might choose his business over the competitor. So the problem here wasn't like a renegade agency not following the law. The problem is that the law itself was unconstitutional, and so that's where we come in.
Yeah, it seems like that really turns the entire sort of American free enterprise system on its head. So, Justin, can you talk a little bit more about the competitors here? How did that actually work in Abdallah's case? Did the government give them notice that, somebody wants to compete with you, now's your chance to come in? How did they get inserted into the process?
Well, you're exactly right. On top of all of the other courageous things that everyone has to do who wants to start their own business, and Will went through some of them, even once Abdallah had done all that, had obtained financing, had obtained an agreement to purchase a shuttle van, then he had to apply with the PUC. He actually spent 2 years trying to get approval from the PUC. And at the very beginning of that process, the Public Utilities Commission in Colorado sent a notice to the existing company saying, hey, just so you know, someone wants to compete with you. Do we have your permission to allow them, or do you object? Well, guess what they're going to do? When you ask someone
insane.
If they right, exactly. And so after that 2 years of just ridiculous paperwork and effort and time and expense, which started after he'd already gone through all the time and expense and effort of starting his own business or setting himself up to. After the end of that entire process, the agency says, well, guess what? We have good news and bad news. The good news is that you meet all the requirements, you're well qualified, you do a good job. The bad news is it doesn't matter because we think you might take a customer away from an existing business, so we have to deny you. That's not the way things are supposed to work in the United States of America.
It's heartbreaking. So because that is exactly what you said, not how things are supposed to work in the United States of America, but it is actually the law, as you noted. How does that get on the books? How does that become the law? Because it is so, you can't imagine that in any other scenario, like a Burger King wants to open, but you have to notify the McDonald's. I mean, it's just insane. What is it about a van company that makes it so special that it needs to have a law like this in the minds of the lawmakers of Colorado?
Well, unfortunately, it's not just van companies or shuttle businesses. We see this in a variety of industries. Most of them are either healthcare related or transportation related, but we've had a number of cases. At IJ, we've actually litigated against more certificate of need requirements than any other organization because they come up so often in our cases. Many of the cases that people think of as taking on transportation monopolies actually involve certificates of need laws protecting those monopolies. And so, for example, I was honored to litigate a case in Little Rock where we got rid of that monopoly, where we convinced the court to rule that Little Rock's taxi cab monopoly was unconstitutional. But that was actually a certificate of need case where it was a CON law protecting that monopoly. And so we see these in quite a few different industries related to healthcare and related to transportation. And they all come from this really misguided notion about half a century ago where people started to think, and I'm actually dubious of their sincerity, but supposedly people thought that if you limited competition, this would actually be a good thing for consumers. Now, anyone who knows anything about economics and consumers and the free market will understand that competition is a good thing for consumers, that when you give consumers more choices, good things happen. But the idea was, again, half a century ago, that if you limit competition and you allow the existing businesses and cartels to know that no one can compete with them, they would be more motivated to invest in their businesses. Again, this is insane, but that was the logic. And then once those laws were created and you created this group of special interests that were benefiting from these laws, it became really, really hard to get rid of them.
So I'm trying to, strongman that argument. Is it that the capital expenses in something like medicine or transportation, if you're buying buses or something, that those are so high that if people feel like, okay, somebody could come in and put me out of business at any moment, they wouldn't be getting the top of the line fleet, for instance, that they're going to scrimp and that ends up hurting consumers because they're getting sort of worse capital expense?
Yeah, I mean, it's a completely flawed argument, but that was the original thinking, supposedly. Now, it's been disproven time and time again, but the problem is that once you have these programs in place and these regulations in place, all sorts of public choice problems are created where it becomes ridiculously hard to get rid of them. I mean, I know I was fortunate to work on a bill repealing con laws here in Florida involving hospitals. It was really, really hard, much harder than any other regulation I've worked on because of all the powerful special interest groups here in Florida, they were hospitals, that have set up roadblocks throughout the legislative process so that those types of reforms can't happen. And it's just, it's much, let me put it this way, it's much easier to stop these laws from being created than to get rid of them once they've been created. And so regardless of the ridiculously flawed and just flat out wrong logic behind them at the beginning, once they're on the books, they're usually there to stay. And we've been busy, trying to chip away at them.
And the craziest part about building on the idea that you were building these transportation protections on like capital investments is that argument came from the old railroad commissions. The idea that you needed to lay miles and miles, however much track, so you could have trains driving across the country, that was the investment that they were trying to protect. Now you're talking about literally using a car or a shuttle or a bus or a van. That's the investment they're talking about. And just when you think about it from a common sense perspective, the opposite is true. Instead of protecting the capital investment, it takes away any incentive whatsoever for the existing companies to get better vans, to get better safety equipment, to get better drivers, to treat their employees better, to treat their customers better. Because as we know, when there's no competition, there's no incentive to improve. So the idea that this is protecting capital, it's just factually untrue.
And the agencies will even admit this, right? The agencies will say, well, we've had all sorts of problems and complaints and customers aren't well served, but that doesn't mean the service is inadequate. That doesn't mean we have to let someone new come in and compete. We don't know that competition would improve things. And so even though things are really, really flawed and we need all sorts of reform, we also have to follow the CON law. And it's just insane.
And that literally happened to Abdallah. In his decision, in the written decision that the commission wrote, they said, well, yes, there are people in Steamboat Springs who can't afford the shuttles. There are people in Steamboat Springs who had bad experiences, who can't get shuttles. But that doesn't mean the service is inadequate or that we need to improve it or that there's any benefit to competition. No. We need to protect the market share of the existing companies no matter what. The idea that it somehow improves service just factually is wrong.
And it seems like in addition to the obvious incentives that the the existing companies have, there's probably a bit of just sort of old-fashioned government power incentive as well. Because in Colorado, isn't it actually called a regulated monopoly? And the idea that, okay, well, this is so important to the people of Colorado that we, the overseers of the bureaucrats and regulators of Colorado we just need to be so involved in the administration of these services. Is that potentially something that comes into play a little bit?
That's exactly it. And the amount of scary, horrific bureaucratic jargon that comes into this case. I mean, Abdallah can't open his shuttle because public convenience and necessity doesn't require it. And there is a regulated monopoly that we need to ensure that having one company, it makes better service when they don't have to worry about upstarts competing with them. Note, none of this applies, by the way, to Uber or Lyft or any of the other companies. That they don't have the power to touch. It just applies to the one guy trying to make a better life for his family. That's the person that is the problem for the big boys.
Yeah, and just like we always see with these types of regulations, what ends up happening is the rich, powerful groups and people end up weaponizing these regulations against the immigrants, the disadvantaged people, the people trying to work their way up the economic ladder. Rich people can afford lawyers and lobbyists and everything else. Abdallah can't. Thankfully, there are groups like the Institute for Justice, which thanks to our donors can provide him free assistance. But otherwise, he can't fight with them. He doesn't have the resources they do. He's trying to pursue the American dream. He hasn't made it yet the way they have. And they're trying to keep him out. And it's David versus Goliath. Like so many of our cases, it's the little guy taking on the big guy. And unfortunately, it's big government teaming up with big business to hurt people like Abdallah. And it's just wrong.
Yeah. Everyone always says that if there's a McDonald's, you don't need a Burger King. Think about it differently. It's if McDonald's and Burger King teamed up together to say we don't need Grandma's Burger Shack. That's what it really works.
Oh, and it sounds like it's a system that richly deserves the lawsuit that you both have served up for it. Let's talk about that. As you think about this, like constructing the lawsuit, looking at these laws, the history, and sort of the entrenched nature of it, Justin, you talked about how difficult it is to deal with legislatively. As you look at dismantling it through a lawsuit, how do you start to go about putting that lawsuit together?
There were two main pieces that had to come together. And first and foremost, we have to talk about Abdallah. Abdallah he is the perfect spokesperson for how these laws hurt. Not just the little guy, not just an immigrant trying to make his life a life better for his family. He is someone who went about this the right way and fought for what is right and believes in not just helping himself, but helping everyone beat an unjust law. So that's number one, is having the right client. And then number two is we really narrowly tailored our legal challenge to what the law in Colorado is. And that is that this violates the due process clause of the Colorado Constitution. And the idea is that the Colorado Supreme Court has already said that the due process clause protects the fundamental right to earn a living. And that's what this is, the right to start a business, to pick yourself up from the bootstraps, to use a cliche, to do what is right for you and your family, to be Abdallah. And separately, that the due process clause supports the idea that you can't just use the government power to protect one private industry from another. And doing so is unconstitutional. And just me, or that sound exactly like what is happening here. They're protecting the existing shuttles from perfectly fit qualified competition. So we are challenging it just under that particular clause, the due process clause.
And that's so important. We've handled so many CON challenges, either healthcare related or transportation related. We actually filed one a few months before, this case in Colorado and Nebraska, taking on a restriction that says our client Mark can drive people to the grocery store, but not to the pharmacy because that qualifies as non-emergency medical transportation. I mean, we do so many of these cases. And what we found is it really does matter where you are and which precedent you're using, which provision you're using. And so sometimes, like in the Little Rock case I mentioned, there's a provision in the state constitution we can use, like there it was an anti-monopoly clause. Other times, like in Colorado, we hope to use, and also in Nebraska, there is state Supreme Court precedent that's stronger than the federal precedent. And state Supreme Courts are allowed to do that because they're the courts of last resort for their respective state constitution. And so before we ever file a case, we need to do tons of research looking at the precedent in the federal circuit where they're located, looking at the state Supreme Court precedent, looking at the text of the state constitution to see if there's anything special or different in there. And those factors matter so much, where we know if we're going into state court in a state where there's good state Supreme Court precedent, like there is in Colorado and like there is in Nebraska, our chances are much higher than if we're relegated to the federal rational basis test, as we have been in some of our other cases, particularly some of our healthcare related cases. And it just makes such a huge difference in our likelihood of success. That doesn't mean we don't still bring those cases in federal court. I mean, sometimes you don't have anything better to rely on and you need to bring the case for a number of reasons, primarily because it's the right thing to do. But we always make sure we check to see if there's something special about that state constitution or state Supreme Court precedent that will up our odds. And if there is, we use it.
So when you are coming at it from the perspective of the federal constitution and trying to overcome the rational basis test, it's fairly clear, even for a non-lawyer, to see how those cases would tie together because you're relying on the same federal provisions. You're kind of looking potentially to the same cases over and over and over again to support your arguments in all of these different jurisdictions. When you are doing it under state constitutions and potentially under different provisions, different types of provisions in state constitutions, how do you stitch those together strategically? Is it really just consequence-based, where the thing that matters most is that the law is gone in this state, the law is gone now in this state, the law is gone in this state, and then all together that fits to make the country more free, and that's really what we care about? Or can you build on them in other cases, even though you're dealing with different states and their own constitutions?
Yeah, it's really both, right? I mean, obviously, first and foremost, we have a duty to our client to win the case. And so we do just copious amounts of research, looking at all of the different potentially useful state constitutional provisions, all the state Supreme Court precedent, applying them, kind of where the trend is. I mean, just tons and tons of research before we figure out kind of what the strongest arguments are, what the government's possible counter-arguments might be, how would we rebut those. I mean, just the amount of strategy that goes into our case filings is just incredible. But then over and above that, you're right that, when we have multiple strong claims that we can make, we're very well aware of the impact we can have even in other states. And many, many states will have similar state constitutional provisions. And so we know that if we're bringing, say, an anti-monopoly clause case, 20 states have those provisions. Or we know that if a state Supreme Court has interpreted its due process clause in a way we like that's better than the federal rational basis precedent, we know the other states whose Supreme Courts have said something similar, where we might be able to export this precedent to those states. And when we get up to those state Supreme Courts, suggest to them that they should take a similar approach. And so, yes, we are an impact law firm. We're a public interest law firm. And so we're always looking to make things as free as possible for as many people as possible.
Have you noticed in the areas where we've been successful that, that idea of, the states as laboratories of democracy? And we were talking earlier in the conversation about all of the arguments in favor of these laws, like where you go to, let's say that we're successful, when we're successful in Colorado, we go then to Nebraska and say, look at what happened in Nebraska, and none of these bad things came to pass. I guess this is a little bit of a different take on that consequentialist perspective. Do courts ever consider that? Do they look purely at the law, or do they look around and say, okay, this is what these laws were purported to do. It is very clear they are not doing that, and we have a demonstrable evidence here that none of the bad things the other side claims could happen do happen. Is that something that they ever look at?
It depends on the test. Right? It depends on the test. So there are certain parts of the Constitution, the state and federal constitutions, that the courts still care about, and certain parts they don't. And if you're in one of the parts that gets meaningful judicial review with an engaged judge, then that evidence matters. And there's a ton of it. All of the arguments for cons, as well as many of the other regulations we take on, have been disproven time and again, oftentimes, including with CON laws. Many states won't have that law that we're challenging in a particular state. And in those states that don't have it, nothing bad is happening. If anything, things are much better. And that's extremely persuasive evidence. But it only matters if we're litigating under a constitutional provision that the courts still care about, where they're going to apply meaningful judicial review instead of judicial abdication. Unfortunately, if it's, say, for example, the federal rational basis test, that type of meaningful judicial review doesn't typically happen. And no matter how much evidence we show the judge is going to hypothesize and either themselves or agree with hypotheses presented by the government sometimes that just are totally disproven, but it could conceivably be true. Aliens could come down, and who knows what could happen. And so
they'll need a shuttle service.
you never know, right?
We want to make sure it's the very best one.
Right. And so it really just all depends on whether facts matter. If facts matter, if evidence matters, we usually win. If not, then it's much harder for us. And to our credit, even when facts don't matter, even when it's a federal rational basis test, we still win more often than most groups. It's amazing that we ever win those cases, and we do a remarkably high percentage of the time. It's just much, much more difficult. I wish all constitutional clauses were respected. I wish all judges always engaged in truly engaged judging, because then we'd win almost all of our cases.
And I like to think that the more we win, the more we're going to win. Because every time we raise a challenge like this, the state comes in and says the same fake parade of horribles that never happens. And each time we get to point to our last case and say, Justin won in Little Rock, IJ won in Little Rock, nothing bad has happened. As a matter of fact, it's better for the companies, it's better for the citizens, it's better for the city. It works. There's no horrible things. And when the aliens come down and need a shuttle, they'll be able to pick and choose and have the best conceivable shuttle for their alien needs.
Well, let's talk about the history. Kind of to this exact point, what has actually happened in Colorado. So this is not the first time that we have been in Colorado trying to improve transportation freedom. Can you talk about where things were in the 90s and IJ's first foray into trying to open things up?
Yeah, it's kind of neat that we're going back to Colorado, because you're right, Melanie. In the 90s, we had a case taking on a transportation con. That one involved taxis. We represented Leroy Jones and Annie Ibong. And it was a law that was remarkably similar to the law we're challenging now, but it involved taxi regulations. And what happened there was, after we filed the lawsuit, the legislature repealed the parts of the law that IJ was challenging. And so our clients were able to have their taxi businesses, which was great. But the reform was very narrow and focused in on taxis, and not just taxis, but really just taxis in Denver. And so now we get to go back and try to create that precedent that we weren't able to create when the reform was passed, because that moots the case, obviously. And so now we get to go back and hopefully get rid of these cons for the entire transportation industry, not just that particular subset involving taxis. And I'm excited.
All right. So with that, final question. Will, what will it mean for Abdallah if we win? Obviously, he can open his business, presumably. This would force a successful lawsuit would force the Public Utility Commission to take back their denial. What would it mean more broadly? Is this something that really is only going to affect future shuttle services, or is it bigger than that?
Freedom. It means more freedom. I mean, as Justin alluded to, this is our chance to bring increased transportation freedom and bring honest competition to the rest of the state. We were able to do it in Denver, and it's a chance to bring it throughout all of Colorado. So what will it mean? As you said, Abdallah will absolutely be able to start his business. More, the idea that no qualified entrepreneur should ever have to get the permission from their competitors before they get a chance to open up their company or open up and compete. And what can it mean more broadly? As we were talking about with the rational basis test, the goal is to export this, to show that certificate of need laws do not work. They don't help, and to try to eliminate them, not just in Colorado, but throughout the entire country, because that's really the goal, is to create a freer society for everybody, one step at a time.
Yeah, that's exactly right. I mean, there are so many Abdallahs out there. Maybe they want to open up a taxi business. Maybe they want to open a shuttle business. Maybe they went to medical school and they want to open up some sort of medical services business. The impact we can have is huge. Abdallah's wonderful, and just helping him would itself justify the lawsuit. But there are so many Abdallahs out there, and if we create precedent for this Abdallah, then all the other ones can be helped. They can start their businesses. They can create jobs. They can innovate and make the world better for customers and society as a whole. It's just, when you think about the impact this can have, it's just amazing.
Well, thank you both for your time. Thank you for filing the lawsuit and bringing it to the bad guys who so richly deserve to be sued. And thanks to those listening for joining us for today's Deep Dive. You can get more episodes wherever you get your podcasts or on YouTube. And don't forget to subscribe.